My name is Claire. I'm 34, and I am a licensed real estate attorney in Atlanta, Georgia. I know what a deed transfer looks like. I know what undue influence means in a probate court. I know the difference between a gift and a taking dressed up as a gift. And I know, down to the recording number at the county clerk's office, exactly what it means when your name disappears from a property you paid for, and someone else's name appears in its place. I know all of that, because it is my job to know it. I have represented clients in property disputes for 7 years. I have sat across tables from people who believed that a signature on a piece of paper was the end of the conversation, and watched them understand, slowly, that it was only the beginning. I did not expect to be sitting on my own side of that table. My house, not my parents' house, not a family property, not something inherited or shared or disputed from the beginning. Mine. I bought it at 29. A 3-bedroom craftsman in Decatur, 4 blocks from the MARTA station, with a front porch that faced west and caught the evening light in a way that made every difficult day feel slightly more manageable when I came home to it. I paid $287,000 for it. I put down $57,000. Saved over 5 years. From a salary I had built carefully and protected carefully and spent carefully because I understood. From watching my parents. Exactly what happened when you didn't. I had the house for 3 years before my parents asked to move in. I said yes. Because they were my parents. And because my father's health had been declining. And because the apartment they were renting in Stone Mountain was expensive for what it was. And because I had a spare bedroom and a driveway and enough room for the 3 of us to live with dignity. I said yes, and I gave them a key. And I moved my home office into the smaller bedroom. And I made space in my house the way you make space for people you love. I was gone for 4 months. A work assignment. An extended contract with a municipal client in Birmingham. I had negotiated remote work for most of it, but the final phase required presence. And I packed a bag. And I kissed my father on the forehead. And I told my mother I would be back by March. I came back in February, 3 weeks early, because something felt wrong. And when I walked into my house on a Tuesday afternoon with my key, and stood in my own living room, and opened the envelope my mother had left on the kitchen counter, addressed to me, in her handwriting, I understood what wrong meant. The house was no longer mine. My parents had transferred it to my brother while I was in Birmingham, without telling me, without my consent, without my signature, on a quitclaim deed that had been filed at the DeKalb County Recorder's office 6 weeks after I left. My brother Marcus's name was on the deed. Mine was not. Welcome to the family ledger, where we talk honestly about money, family, and the moments when the people who are supposed to protect you become the ones you need protection from. If you've ever had something taken from you by the people who should have known better, this story is for you. Subscribe, drop a comment, and let me take you back to where this started. I want to tell you about my family before I tell you what they did, because the action without the context is just a crime story. And this is more than that. My parents, Robert and Diane, are in their early 60s. My father worked for 30 years as a postal carrier. My mother worked part-time as a teacher's aide and managed the household with the particular competence of someone who keeps everything running without requiring anyone to notice. They are not malicious people. I want to say that clearly and early, because the rest of this story could make them sound like they are, and I do not believe that is the full truth. They are people who love their son, in the way that parents sometimes love one child, with a particular urgency that comes from believing that child needs more than the other one. My brother Marcus is 31, 3 years younger than me. He has the particular quality of people who have always been caught and always been forgiven. So many times that the catching and the forgiving have merged into a single experience, and the accountability has been quietly removed from the equation. He has borrowed money from my parents that was never repaid. He has started things that did not finish. He has arrived at family dinners with explanations for absences that everyone accepted without examination, because examining them would have required a conversation nobody wanted to have. He is not evil. He is someone who learned, very early, that the consequences of his choices would be absorbed by the people around him. And he learned it, because my parents taught him. The transfer, when I reconstructed it, happened like this. 6 weeks after I left for Birmingham, Marcus told my parents he was in trouble. Not a small trouble, a specific one. He had been renting an apartment in Marietta and had fallen 4 months behind. And the landlord had filed for eviction. And the court date was in 3 weeks. And he needed somewhere to go. And he needed it immediately. My parents, living in my house, in my spare bedroom, with my key, made a decision. They decided, without calling me, without asking me, without telling me, that Marcus needed the house more than I did. They found a notary. They signed a quitclaim deed, transferring the property from my name to Marcus's name as my authorized representatives, except they were not my authorized representatives. I had not given them power of attorney. I had not signed anything authorizing them to transfer my property. I had given them a key to my house and a spare bedroom and the trust that comes from being someone's child, and they had used all three. To give my house to my brother, the deed was filed on a Thursday. Marcus moved in the following weekend. My parents moved into the second bedroom, and nobody called me. For 6 weeks, I was living in Birmingham, paying the mortgage on a house that had already been transferred out of my name, and I did not know. The envelope on the kitchen counter. I want to tell you about it, because it matters, in the way that the specific details of betrayal matter. When the betrayal comes from someone who loves you. My mother had written my name on the front, her handwriting, which I have known since I learned to read, which wrote my name on birthday cards and permission slips and the notes she packed in my lunch in 4th grade. Inside was a single page. She explained what they had done. She said they had been in a desperate situation. She said Marcus had nowhere to go. She said she knew I would understand, because I had always been the strong one, the one who figured things out, the one who would be okay. She said she was sorry. She said she hoped I would forgive them. She said. The house was still in the family. I read that letter 3 times. Then I set it on the counter, very carefully, the way you set something down when your hands need to do something deliberate, because the alternative is something you cannot take back. I took out my phone. I opened the DeKalb County Property Records database, which I know how to access because I am a real estate attorney, and I searched my address. The deed was there, filed 6 weeks ago. Grantor. Robert Allen and Diane Allen, acting as authorized representatives of Claire Michelle Allen, grantee. Marcus Dion Allen. Consideration, $0. I looked at that line for a long time. $0. My brother had received my house, my $287,000 house, for $0. On a deed signed by my parents, who had no authority to sign it, filed at a county recorder's office that had no mechanism to verify the authorization. 6 weeks ago, while I was in Birmingham, paying the mortgage, I put my phone in my pocket. I walked to the kitchen. I made a cup of coffee. I sat at my own kitchen table, in my own house,
that was no longer legally mine, and I drank it slowly. And I thought about every step I was going to take, and in what order, and what each one would cost, and what each one would accomplish. I finished the coffee. Then I called my supervising partner at the firm. If you've ever come home to find that something was done in your name, without your name, leave a comment. Tell me what that moment felt like. And if you haven't subscribed to the Family Ledger yet, do it now. Because what I filed in the next 72 hours changed every assumption my family had made about what they could do and what I would accept. My supervising partner is a woman named Gloria. She has practiced real estate and property law in Georgia for 22 years. She has the particular quality of attorneys who have seen enough that very little surprises them, and who respond to the surprising things with the same methodical precision they bring to everything else. She picked up on the second ring. I told her everything in 9 minutes. The transfer, the quitclaim deed, the $0 consideration, the letter on the counter, the 6 weeks. She was quiet for a moment. Then she said, "Claire, do you have any documentation of the original purchase in your name?" I said, "Yes, the original deed, the mortgage documents, the closing disclosure, all of it." She said, "Do you have anything establishing that your parents had no power of attorney or authorization to transfer on your behalf?" I said, "Nothing exists because nothing was given." She said, "That is the strongest possible position." She said, "What you're describing is a fraudulent deed transfer. Your parents signed as your authorized representatives without authorization. In Georgia, that makes the deed void, not voidable. Void. It has no legal effect. The property never legally left your name," she said. "We need to file 2 things immediately. First, a quiet title action to formally establish that the quitclaim deed is void and that title remains in your name. Second, a lis pendens, filed at the DeKalb County Recorder's Office, which puts any future buyer or lender on notice that the property is subject to litigation." She said, "How quickly can you get me the documents?" I said, "I have them in cloud storage. I can send them in 10 minutes." She said, "Send them. I'll have the filings drafted by morning." I said, "Gloria, hey, Marcus is living in the house right now, with my parents." She was quiet for a moment. Then she said, "Claire, this is your house. Do you understand that?" I said, "Yes." She said, "Then, let's make sure the record reflects it." I want to tell you about the 72 hours after that phone call, because they were the hours that mattered most. And because I think the honest version of them is more useful than the dramatic version. The honest version is this: I did not sleep well. Not because I was afraid of the outcome. I understood the law clearly enough to know the outcome was sound. But because the people in my house, in my spare bedroom, were my parents, and the name on the fraudulent deed was my brother's, and the letter on the counter was in my mother's handwriting, and none of that changed what I had to do. Gloria filed the quiet title action on Wednesday morning. The lis pendens was recorded at the DeKalb County Recorder's Office by Wednesday afternoon. On Thursday, Marcus received formal legal notice. He called me Thursday evening. His voice, when he called, had the quality I recognized from 31 years of watching him navigate consequences. Fast, slightly too casual, reaching for the register of someone who has been inconvenienced rather than exposed. He said, "Claire, this is a misunderstanding." I said, "Marcus, what part of it is a misunderstanding?" He said, "Mom and Dad had the authority. They were living there. They were taking care of the place." I said, "Living in my house and having legal authority to transfer my house are 2 different things. You know that. I know that. And Gloria knows that." He said, "You're going to take your own family to court." I said, "I'm going to recover my property through the appropriate legal channels." "Yes." He said, "Where are Mom and Dad supposed to go?" I said, "Marcus, that is not my problem to solve right now." He said, "Claire," I said, "you received my house for $0 on a deed that was signed without my authorization. I have filed a quiet title action. The list pendants has been recorded. I would advise you to retain an attorney." I hung up. I sat in the Birmingham apartment I had been renting for 4 months, paying rent, while simultaneously paying the mortgage on a house that had been transferred out of my name. And I looked at the ceiling for a while. Then I ordered dinner, because what I needed most, before everything that came next, was to eat something and be quiet and let the process I had set in motion move at the pace it was going to move. My mother called Friday morning. Her voice, when she called, was the voice I had heard at the worst moments of my childhood. The voice she used when something had gone wrong, and she was reaching for the words that would make it smaller than it was. She said, "Claire, baby, we need to talk." I said, "Mom, I know why you're calling." She said, "We didn't mean for it to go this far." I said, "How far did you mean for it to go?" She was quiet. I said, "You transferred my house to Marcus without my knowledge or consent. You signed as my authorized representative, but you are not. You filed a deed at the county recorder's office that removed my name from a property I purchased with money I saved over 5 years. How far? Exactly. Did you mean for it to go?" She said, "We were in a desperate situation. Marcus had nowhere." I said, "Mom, I've heard that sentence my whole life. Marcus had nowhere. Marcus needed help. Marcus was in a situation." And the answer, every time, was that someone else paid the cost of Marcus's situation. This time, the cost was my house. She started to cry. I want to tell you what I felt when she started to cry, because the honest answer is complicated. I felt grief, real grief, for the mother who packed my lunches and came to my school plays and meant every word of the love she had given me my whole life. I also felt, with equal clarity, that her tears were not an argument, that loving someone and doing something wrong are not mutually exclusive, and that the deed was filed, regardless of the tears, and the process was moving, regardless of the grief, and my house was my house, regardless of how desperate anyone's situation had been. I said, "Mom, I love you. That has not changed." I also said, "The quiet title action is moving forward. Gloria will handle all formal communication from here." She said, "Where are we supposed to go?" I said, "I don't know yet. But that is a conversation for after the legal process is resolved." I said, "I'll call you Sunday." I hung up. The quiet title hearing was scheduled for 6 weeks after the filing. In those 6 weeks, Marcus retained an attorney, his attorney's position, delivered through formal correspondence to Gloria, was that my parents had been acting in good faith as my de facto representatives. Given that they were living in and maintaining the property during my absence, and that the transfer had been made with my implied consent. Gloria's response, delivered in the measured tone she used when she knew she was right and was saving everyone time, was 3 sentences. She said, "Implied consent does not exist as a legal standard for real property transfer in Georgia." She said, "The grantor must provide explicit written authorization for any representative to convey real property on their behalf." She said, "No such authorization exists, and the deed is therefore void ab initio, from the beginning, as if it never happened." Marcus's attorney requested a settlement conference before the hearing. Gloria advised me to attend. I attended. The settlement conference was in a small conference room at a mediator's office in Buckhead. Marcus came with his attorney. I came with Gloria. Marcus looked across the table. The way he always looked when a situation had arrived somewhere he had not planned for it to arrive. Not remorseful. Recalibrating. His attorney opened with a proposal. He said his client was willing to cooperate with the quiet title action in exchange for a 6-month period to vacate the property and a waiver of any claims for the mortgage payments made by Claire during the period the deed was in Marcus's name. 6 months. And he wanted me to waive the mortgage payments. I had paid 6 weeks of mortgage on a house that was in his name. I looked at Gloria. She looked at me. I said, no. His attorney said, Miss Allen, my client has been living in the property in good faith. I said, your client received my property for $0 on a fraudulent deed. He has been living in my house without my consent. I will agree to a 30-day vacate period, which is the standard notice period under Georgia landlord-tenant law, and I will not waive the mortgage payments, which will be included in the damages claim if this proceeds to hearing. Marcus said, Claire. I looked at him. He stopped. His attorney conferred with him quietly. Then he said, 30 days and no damages waiver. I said, yes. We signed the agreement. Gloria filed the consent order with the court the following morning. The quiet title action was resolved in my favor. 14 days later, my name was restored to the deed. Marcus had 30 days to vacate. He was out in 26. I know because I drove to Decatur on the 26th day and stood on the front porch with my key and unlocked my own front door and walked through my own house, room by room, the way you walk through something you thought you might have lost, checking that it is still what it was. It was, mostly. Marcus had taken the dining room light fixture, which he had not purchased and had no claim to. He had left a large stain on the living room carpet, origin unclear, and had removed the smart thermostat I had installed 2 years earlier. Gloria sent a formal demand letter for the replacement costs. He paid within 30 days, not because he wanted to, because the alternative was small claims court, and he had already watched me go to a settlement conference with a property attorney. And he understood, finally, that I was not going to absorb the cost of his choices this time. My parents. I want to tell you about my parents, because they are the most complicated part of this story. And because leaving them out would make the story tighter than it actually is. They had moved out of the house when Marcus moved out, because they had been living in his portion of the arrangement, and when the arrangement collapsed, they had nowhere to go. They stayed with my mother's sister for 3 weeks. Then my mother called me, not about the house, not about the legal process. She called on a Sunday, the way she always called, and she said, Claire, we don't have anywhere stable right now. Your aunt's place is too small. Your father's health is getting harder to manage. We need help. I sat with that for a long time. Not the call, the weight of it. My parents had taken my house, given it to my brother, left me paying a mortgage on a property I no longer legally owned for 6 weeks, and were now calling to ask for my help. The pull was there. The old pull. The one that lives in the chest of every person who has ever been the functional one in a family. The one that calculates, it is easier to help than to manage the conversation if I don't. I felt it. I also felt, with equal clarity, what it had cost me the last time I answered it without conditions. I said, Mom, I will help you. But I need to tell you what that looks like and what it doesn't look like before we go any further. She said, okay. I said, I will help you find a senior living community that fits Dad's needs and your budget. I will contribute to the first 3 months of costs while you stabilize. I will drive you to appointments when I can. I will call every Sunday. I said, I will not give you a key to my house again. I will not offer you a room in my home again. Not because I don't love you, but because I now know what happens when access becomes authorization in this family. And I'm not willing to learn that lesson twice. She was quiet for a long time. Then she said, that's fair. 2 words. That's fair. I had expected more resistance, more grief, more of the voice she used when she was reaching for words to make something smaller. Instead, she said, that's fair. And I understood, in that moment, that she had been sitting with what they had done for the weeks of the legal process, and the settlement conference, and the 26 days of Marcus's vacate period. And she had arrived somewhere that I had not expected. Not fully, not completely, but somewhere. I said, "Okay, Mom, let's find you somewhere good." We did. There is a senior living community in Clarkston, 12 minutes from my house, with a medical support program that suits my father's needs and a price point that works with their income and my contribution. They moved in 2 months after the quiet title was resolved. My father's health is being properly managed for the first time in years. My mother calls on Sundays. We do not talk about the deed. We talk about other things, real things. The garden she has started on her small patio, the book club she has joined, my father's improvement on the weeks when the medication is working. Small things. The kind of things that do not have a right answer and do not require anyone to be wrong. Marcus called me once. After the vacate period, he called on a Tuesday evening, 3 months after he moved out, from a number I didn't recognize, which told me he had expected me not to pick up. I picked up. He said, "Claire, I want to say something." I said, "Okay." He said, "I knew it was wrong. When Mom and Dad told me what they were doing, I knew it wasn't right. I should have called you. I should have told them no. I didn't. Because I needed somewhere to go. And I told myself it would work itself out." He said it quietly, without the recalibration, without the fast voice reaching for a register it didn't belong in. Just the sentence. Sitting there, carrying what it carried. I said, "I know." He said, "Are you ever going to forgive me?" I said, "I don't know yet. Forgiveness is a process, not a decision." "I'm in it. I don't know where it ends." He said, "That's honest." I said, "Yes." He said, "I'm sorry, Claire." I said, "I hear you." We said goodbye. I sat in my living room, in my house, on the couch I had bought when I moved in at 29, with the evening light coming through the west-facing windows the way it came every Tuesday. And I sat with the call for a while, not with anger, not with triumph, with the particular weight of a thing that has been through something real and is still standing and is trying to figure out what standing here, after all of that, actually means. I want to tell you what the house looks like now. The dining room light fixture has been replaced. Better than the original. The carpet stain is gone. Professional cleaning. Logged and billed in the demand letter. The smart thermostat is back. Same model. Marcus paid for it. The front porch still faces west. The evening light still comes in at the angle that makes difficult days feel slightly more manageable. I come home to it every night. It is mine, in the legal sense, which it always was. Even when the deed said otherwise, it is mine, in the earned sense, which is the sense that matters most. I saved $57,000 over 5 years for that down payment. I drove 4 blocks from the MARTA station and stood on that porch and knew it was the right place. I paid the mortgage for 6 weeks while someone else's name was on the deed, and I paid it without missing a payment, because the house was mine, regardless of what the recorder's office said, and I was going to behave accordingly. I think about that sometimes. The 6 weeks of mortgage payments on a fraudulently transferred property. There is something in those payments that tells you more about who I am than anything else in this story. I did not stop paying, because it was my house, even when the paper said otherwise. Here is what I know, after all of it. A deed is a document. A document can be wrong. A document can be fraudulently executed, improperly filed, legally void from the moment it was signed, and still sitting in a county recorder's database, looking like the truth, until someone who knows the law looks at it carefully and says, "No, this is not the truth. This is paper. And paper can be corrected." If someone has transferred property out of your name without your authorization, hear this. In most states, a deed signed by someone claiming to represent you without documented legal authority is void, not voidable. Void. It has no legal effect from the moment it was executed. You have not lost your property. You have a fraudulent document in a database. Those are two different things. Call a real estate attorney. File a quiet title action. Record a lis pendens. Get your name back on the deed. The process exists. Because this happens. More often than anyone wants to admit. And most often. It happens within families, where the assumption is that love grants access. And access grants authority. And authority means you can sign. It does not. Love is not a power of attorney. A spare key is not a deed. In a desperate situation. However real, does not authorize anyone to give away what belongs to you. My parents loved me. They also took my house. Both of those things are true at the same time. And I have learned to hold both without requiring one to cancel the other. What I will not hold is the version of events where I absorb the cost of someone else's desperation and call it love, and let the record stand uncorrected. The record has been corrected. The house is mine. The deed says so. And this time, it is right. That's my story. A quitclaim deed. A letter on the counter. And a quiet title action filed before the week was out. If this found you at the right moment, share it with someone who needs to know that a fraudulent document is not a final answer. Drop a comment. Tell me if someone has ever used your trust as their authorization. I've read every one. Subscribe to the Family Ledger. I'll see you in the next story.